Distinguished participants, ladies and gentlemen, I welcome you all to Monrovia, Liberia, the 2019 African Bar Association Annual Conference via video teleconferencing of the Privacy Rules section. Distinguished colleagues, you are aware that this Privacy Rules Conference was organized to be a very big conference that was supposed to be holding at the annual conference in Cairo. But unfortunately, the Cairo conference had to be postponed and relocated to Liberia due to some very, very serious circumstances which were far beyond the control of the African Bar leadership. Unfortunately, all our revered participants at the Privacy Rules session who had prepared so hard are unable to make Monrovia. But the importance of privacy rules to our daily lives and to our profession and to our businesses is so important that the leadership of privacy rules worldwide deemed it fit that this session should also benefit in Monrovia. And that is the reason why there had to be a video recording for you to have the views of some of the participants who would have met face-to-face had the Cairo conference taking place. They are very giant people in their own rights. We will take time out later to introduce the privacy rules worldwide, in which the African Bar is an honored member. We are fortunate to join the World Alliance as members, and we have attended several meetings. The first conference was held in London last year. This year, this conference of World Privacy Alliance we hold in Toronto in Canada. The African Bar will be represented there by me. I have been invited, I will be present there. But the essence of privacy rules and the intricacies as the world moves its strides through technology and as a lot of complexities come to place cannot be overemphasized. And that's the reason why we must take time off to look and listen to what these participants are saying and then make our own contributions. I want to thank the Vice Chairman, or otherwise who I regard to as the coordinator of the Privacy World Alliance, a very good friend of AFBA, a great friend of Africa, a man who is so hardworking that his name, I call him Mr. Hardwork. I'm talking about Mr. Andrew Igazi, who we've been fortunate to be working with and who is behind the scene in making the alliance so big. He will introduce himself later, along with, we introduce also the other panelists. And I'm supposed to, Alessandro is also here to discuss a few things. So once again, welcome. I hand over to Andrea.
Thank you very much, Honorable President. You couldn't introduce better the idea behind the Privacy Rules Alliance and the scope and the reason why we are so pleased to be partnered with the African Bar Association and with you as his wise and visionary leader, who, when we got in touch with you and when we got in touch with the African Bar Association, understood that in the world of technology is particularly important to start cooperating with colleagues, lawyers, experts, cybersecurity experts including, all around the world, in order to engage in what we are trying to promote. And what we are trying to promote, and we are succeeding to promote, is a culture of awareness of what privacy is, of sensitivity to the protection of data, and understanding that a lawyer in the 21st century needs to be very much aware of the complexities that you were mentioning and of the importance of cooperating with colleagues all around the world. And this is exactly the reason why in May last year, we were honored to submit to your honorable attention and to the one of the entire board of the African Bar Association a memorandum of understanding with various points of cooperation, in line of which, and we are so thankful to you that you agreed on signing the memorandum of understanding with us, in line of which we started cooperating together, as you mentioned, thanks to your participation in London, thanks to your upcoming participation in Toronto, thanks to this session of the African Bar Association in Monrovia 2019, as we prepared for Cairo. For Cairo, as you know, as you already mentioned, we had invited 9 experts from all around the world to speak. It was impossible for them to readjust their agenda now. So we have organized this video conference with some of them, and I would like to leave the floor to Alessandro in order to present who they are.
Thank you, Andrea, and hello everyone. I would like to thank President Huaifo too and the African Bar Association for giving us this great opportunity. Today we are going to discuss a session entitled Privacy and Telecommunication Laws in Africa, Rights and Opportunities, with 3 members of our alliance. In particular, we will have 1 member from the African continent, that is the first member, Janet Othero. She comes from Kenya, from the law firm OK, and she will discuss Kenya government digital transformation and data protection. She will be followed by our member from Chile, so from Southern America country. His name is Juan Carlos Manriquez from the law firm Manriquez Benavides, and he will discuss a presentation entitled Rule of Law 4.0, how the public and private sectors shall adapt to fully respect the HR into the digital economy. And then he will be followed by Ken Morris. Ken Morris comes from a tech firm, a cybersecurity firm named ConnectIQ from the United States. And he will present a discussion entitled Data Protection Best Practices, Inadequate for Privacy and Regulatory Compliance, Time for a 21st Century Model.
Thank you very much, Alessandro. If I can add something to before we give the floor to our speakers, I would like to underline that, as I said before, we are really honored to be in the condition to bring our experience to the lawyers of the African Bar Association. For us, it's fundamental to cooperate with the African Bar Association, definitely, with its board, of course, with its Honorable President Hannibal Uvaifo. And we are very pleased that little by little we are closing partnerships with lawyers in African countries. Janet Othero from OK Law from Kenya will be speaking today to you. We recently had also joining our alliance a lawyer from Senegal, a law firm from Senegal. We are about to announce one from Cameroon. Luckily, we have the strong participation from Nigeria that we are very pleased of, with Sagittarian Law Firm, where also the President Hannibal Uvaifo is one of the partners. But we are ready to welcome representatives from all the African countries. So please, all of you who are going to listen to this presentation and are interested to cooperate with us in order to promote privacy and data protection and the business related to technology in your countries, please come and join our alliance. We will distribute all the contacts, and we will distribute also the materials related to privacy rules. And we are really opening the arms through the video today, hopefully next year in person, where the African Bar Association 2020 annual conference will be. But we wait for you to join us, as many as possible and as soon as possible. With this, if President Uvaifo allows, we can give the floor to the various presenters that have been listed by the colleague Alessandro. It's my great pleasure to give the floor to Ms. Janet Othero. Janet is the privacy and data protection expert of Triple OK Law, our Kenyan member. She's definitely one of the most important experts in privacy and data protection in Kenya, and she also has in-depth experience in the African landscape. I don't want to take her time, so I would pray Janet to introduce herself to this very respectable audience of the African Bar Association, and I immediately give her the floor in order to introduce herself and Triple OK Law and their experience on privacy. Thank you.
Thank you very much, Mr. Andrea. Greetings to you participants of the African Bar Association. I hope you're enjoying your seminar so far. My name is Janet Othero. I'm a senior associate with the Triple OK Law Advocates in Nairobi, Kenya. Within our law firm, we have a dedicated practice area to data protection and all matters ICT. So it is housed within our telecommunication, media, and technology department, where we support a lot of corporate entities, startups, and hubs on matters touching on ICT, with key being data privacy and protection around some of the innovations we are seeing them coming up with, some of their continuing products, digital products, and also with the whole process of digital transformation by various entities, including the government. And we just try to help them take into account matters data protection, data privacy, in light of the fact that data is slowly becoming a human rights issue, to say the least, and also a very precious commodity within the corporate marketplace in the world. So I hope you'll be able to enjoy my presentation and my participation in this conference.
Janet, it's a pleasure to have you here. So I would like to immediately start discussing about the topic of today, and we would like to have an overview of what's happening in Kenya and also in Africa, of course. So I would like to start asking you, which is the current status of the legislation there and how things are going?
So Kenya has seen a bit of an empty space when it comes to legislation on data protection. I think that's because our understanding of the need to protect data was not very, the government and stakeholders were not very keen on protecting data until we started seeing a lot of digital products asking for more and more information from users. So we currently, in 2010, when we passed our constitution, there was a provision made for every citizen having a right to having their confidential information being held private. So this was a precursor, or what was supposed to give an indication of the legislation that would come in place. So we are talking 9 years down the line when we have a data protection bill. And the thing is that we have two data protection bills that are somewhat not in conflict with each other, but they're on competing floors of the Senate and the Parliament in terms of seeing which of the houses will pass the bill first. But the one that has gotten a lot of stakeholder comment and seems to be more acceptable and is widespread popular is the one being passed by Parliament. So that is the one I'll keenly concentrate on because it has gone through the paces and is at an advanced stage. So what we've currently seen in the country is that both legislative arms were told to sit down and harmonize the bills to come up with a perfect bill. This is yet to happen. So we currently don't have an effective bill when it comes to data protection and data privacy, which is a bit of an unfortunate situation.
Janet, thank you very much for this overview. It's very important for us also because one of the aims of Privacy Rules and its cooperation also with the African Bar Association is to help governments and parliaments along with its members to enhance the legal framework in the respective countries. So we definitely are available, and likewise, I would say we count on you and your expertise in order in the future to propose any initiative to the Parliament and the government of Kenya in order to enhance and harmonize the legal framework. The question I would have to you, specifically in regards to the data protection bill that you mentioned, is what are the key features of the bill in light of the massive influx of digital products and digital transformation of processes in Kenya?
So the bill heavily borrows from what are some of the major provisions of the European Union GDPR. So it has heavily borrowed in terms of who it defines as a data subject, how it defines data breach. It has also come up with an office that will be known as the Data Commission Office, headed by a data commissioner, who will have the oversight or the overall responsibility of just ensuring compliance and implementation of this bill. Apart from this, it has introduced certain elements of offenses that were not really provided for under any legislation when it comes to non-compliance or data breaches, which is a good thing, because we've currently seen in the local market, we've seen a couple of data breaches from certain organizations that have led to court cases being filed, but our courts not having the capacity to really listen to these cases in the absence of a legislative framework. So we've also seen it give timelines on how some of these data breaches must be reported, how data subjects information must be handled and processed, how they'll go about licensing most of these data controllers and processors, how they'll go about penalizing some of them for non-compliance or non-breaches. And some of the penalties that we see include prison terms and fines going up to a maximum of 5 million or both for certain circumstances, which is almost akin to what the GDPR sought to do. But also we've seen in terms of them just trying to align and probably create a safer space for data controllers and processors to use and collect and process information, but also trying to create a balance where data subjects are still protected at the end of the day. The only challenge we've had with this bill, and it's been subject to a lot of debate, is the fact that state agencies are exempted from the provisions of this bill. Now, this comes after the state has started digitizing some of its processes, including issuing a unique identifying number. And for them to issue this unique identifying number, they've collected all sorts of information from you, including your GPS location. At one point, they were insisting on collecting DNA, but this was fought in court. They've collected any sort of identifying information that you could possibly have that would be able to refer to you. So in light of the amount of this data that the government is collecting and them being exempted from the provisions of this act, we are at a challenge as to how to now fully implement this bill when it becomes legislation, if the state, who is the holder of the largest trove of information, is not subjected to the same obligations as private citizens are. So we wait to see what will happen in such a case.
Okay, and Janet, I'm interested on this last point. I would like to know more about it, and if there are in particular entities or regulators that are active under this point of view, considering that the bill is awaiting the parliamentary and presidential approval.
So the thing we've seen with a lot of, in light of what happened in Europe with the GDPR, a lot of some of the Kenyan entities do serve European citizens or do have partnerships with European countries. So they were forced to comply with the provisions of GDPR in the absence of local legislation, but to the extent that the local laws would allow them to comply. So this is what we'd call best practice in the industry. So some of the corporate entities have just adopted internal policies, privacy policies, terms and conditions, and all those things that are in line with what the GDPR provides for, so as to just stay ahead of the curve, but also just to ensure that if our act comes into place, they are more compliant than they were before it. But also we have regulators like the Central Bank of Kenya, which regulates financial institutions, issuing guidelines on a regular basis with regards to cybersecurity, data breach, and how it should be reported to the regulator, and also some of the risk mitigation processes that some of these financial institutions have when it comes to processing and handling data, and also outsourcing processors. So it's a good move for some of the players in the market where the regulator has taken a step to just issue guidelines, but it's also a good step where corporate entities are taking it upon themselves to come up with standard ways of operating that are compliant with the GDPR in the absence of our laws. So hopefully when the laws come into place, it will be one whole ecosystem where we'll see compliance overall.
Excellent, excellent, very interesting. So let me come to you in the sense that, can you explain to us, can you explain to the audience, to the distinguished colleagues of the African Bar Association now present in the conference, what your firm, I mean, Chapel Okeilo Advocates, is plugging in with respect to the whole of data privacy ecosystem, and what types of legal services do you offer in Kenya and possibly outside, and definitely to all the corporations that come and operate in Kenya?
Yes. So Triple OK Law is a fully fledged law firm which offers a lot of legal services. Apart from that, we are a partner of Meritus Law Firm Worldwide, which is just a network of law firms with more or less a professional relationship where we sort of recommend clients to each other and just adopt best practices that other law firms are using in their country. So some of the services that legal services that we offer with regards to data protection and data privacy include our advisory services. So when it comes to corporate entities, in terms them trying to align or be compliant when it comes to data protection, we offer advisory services. We offer audit services for them to audit their systems, their contracts, to see whether they are compliant with the minimum provisions of GDPR and the pending bill in Parliament. But also we offer some sort of thought leadership. We partner with a lot of players in the market to hold seminars and conferences where participants can come and give ideas, and basically if it's self-regulation, we help them come up with code of conduct when it comes to handling and processing of data. In addition to that, we have a litigation and dispute resolution department, which also handles matters for or against some of our clients who may sue or may have been sued for breaches or not complying with privacy policies as employees when it comes to handling data for some of their clients. Also, in addition to that, we partner with a lot of startups or hubs where people are coming up with the innovative products. So as they're innovating and they're kind of just partnering or acquiring digital products, we come in to just kind of understand the customer journey of some of these products, how they'll be collecting data from the public, how they'll be storing it, how they'll be outsourcing it, and we just advise them on some of the contracts and provisions of the contracts to put in place, but also on the terms and conditions that they'll put on their products and some of the privacy policies they have on their websites. So that's more or less what we do when it comes to data protection and privacy.
Well, Janet, thank you very much. I hardly imagine configuring a law firm that could offer more than what you do. So it's not what you just provide, but actually is the fully fledged service that definitely interests international corporations coming to Kenya to invest, but also, and what I believe is very important, if not even more important, the support that you can offer to startups. So these hummus of new ideas, new entrepreneurs that from Kenya can grow and expand in Kenya and even abroad.
Yes.
PrivacyRules has a special program in particular for cooperating with hubs and startups. So we are very pleased to partner with you and also with Triple OK Law in order to provide this kind of services in the jurisdictions where we are, in Kenya in your case, and you as our exclusive member in Kenya, but also in an international landscape.
Yes.
I am sure that if we were present in the conference hall where all colleague advocates are present in this moment in Monrovia, there would be a lot of questions for you. My warm recommendation to all the lawyers from Africa is to submit questions even in writing to you and to us. We will be definitely, I'm sure, together pleased to answer, or Janet individually for what concerns Kenya.
Yeah.
To follow our activities, to join PrivacyRules from those countries where we are not present yet. And Janet, really our very warm thank you for joining us and to volunteer in order to participate in this session. We believe that thanks to you, we have offered to all the colleagues who look at technology law, privacy, data protection as the new frontier, if we want, of the legal services and legal counseling. You are an inspiration, I would say, for your colleagues from your continents.
Yes.
So thank you once more for joining us. And as we were commenting before, our warm thanks to President Hannibal Ubaifo, which is there and supports so greatly the activities of PrivacyRules and all its members. Thank you very much. And now we will be ready to pass the floor to the next colleagues. Thank you once more, Janet.
Thank you. Thank you very much for the opportunity, Privacy. Thank you to AFBA and President Hannibal Unaifo. I hope that this will lead to more engagement and talk amongst African lawyers, because data protection is a global issue. It's not only a national or a regional issue. So thank you for the opportunity.
Well, distinguished members of the African Bar Association, I am extremely pleased to present to you our distinguished colleague, and I would say also friend, because he's one of the founding members of PrivacyRules, is the colleague abogado Juan Carlos Manriquez from Chile. Juan Carlos is an excellent member of Privacy Rules and a great expert in a variety of subjects, including in particular privacy as a fundamental right. He will have a very interesting presentation for you. Nobody better than him can explain to you how the right to privacy can be not only a right to be promoted, but also an occasion of business. And we will hear this directly from him. Juan Carlos, it's really a great pleasure to have you in this conference. And we would really like to hear from you and to learn from you who you are and your firm in Chile.
Thanks, Andrea. The pleasure is for me. I'm very distinguished to be with you today and with our distinguished members of African Bar. First, I want to salute specifically to Mr. Aníbal Uwaifo, Mr. President of African Bar. He is a very distinguished and very kind colleague, and salute for him. Well, we are prepared to talk about our topics with the community. As you know, our law firm is a private law firm in Chile. We are specializing at this moment in many topics related to criminal proceedings, international affairs, commercial issues, and specifically the last time we are working about the data protection and privacy issues. In this moment in Chile, it's a very capital theme for our legal development and for the enforcement of the civil right protection inside our legal system. I'm very, very, very pleased and honored and very glad in this moment to have your friend with us.
Okay, Juan Carlos, thank you very much. And I'm also pleased to be here and speak with you. And I would like to immediately start discussing our topic of today. Since you are a great expert in both the public and the private sector, I would like immediately to start warming up, discussing about which are the main issues related to privacy in both the sector, public and private sector.
In our point of view, in this moment, the data protection and privacy problems are really a problem of the new rule of law system. When we are talking about this, we are thinking in a rule of law 4.0 system. Why? Because we are viewing this moment the data protection as a civil right. This is our point of view and the start of our analysis. Why? If we try, for example, to answer the one question, which are the main challenges for the public and private sectors in relation to privacy, we have to say, first, we have to need a deep comprehension. We face a new environment in this moment with till now sociological, cultural, political, and economical new factors too in our labor environment. All of this, we think, are defining in this moment the people choices and the people relations with others. People see the government and the corporates as a potential subject to demand answers on an egalitarian field. After, public and private sectors, we think, must to adequate their historic behavior with new and high standards and best practices to recognize the customers or clients' rights to say no. Then, for common people, the data protection and privacy as a civil right permit to make pressure over the legal system and to demand for the commercial strategies. A full respect over the privacy has a real constitutional limit, avoiding the abuse.
Excellent, excellent. Thank you very much. This is very interesting. We want to remember to the African Bar Association colleagues that the core topic we are discussing is in fact what we can define as a rule of law 4.0 concept. So how the public and the private sectors can adapt to fully respect the human rights into the digital economy. So how can this happen? The second question that we have for you, Juan Carlos, is which are the most effective instruments to address human rights into digital economy? Where the public, the companies should start?
We think changing the start points of view, it's necessary to have a new brain in order of this new comprehension. Why? Because we think the data owner is the people, not the corporate, not the government, not the agencies. We have to now, the people is the owner of the data. So the corporates and the governments, we say, should to adjust his structures and proceedings in relation with the people, and cannot living more like in this moment are living. The world is changed, and the level of comprehension about the protection and respect, or the full respect of the rights of the civil rights and the rights of the people, like a capacity of decision about how we want to try our data, is the limit.
Thank you, Juan Carlos. And so if I understood well what we're discussing about, it's, center the new subject of data as people and not just the companies. And under this point of view, I would like to ask if you think that officially recognizing data data protection and the privacy as a civil right would be the answer to this kind of issue, or which is your thinking on that, and if you think it may be applied also to other countries and it can work also in other contexts.
Yeah, it's very relevant you are talking, Alessandro, because we think if data protection and privacy really is a civil right, we are talking about this. You have not only a lyric or rhetoric declaration of principle in a constitutional text, there in a corner into a loose folder, for example. You have an effective weapon to use against each one does not obey it, we think. And so you have a tool to press before the courts an urgent and total protection from the judges. In my personal experience, I want to share with you, please let me this second to share. In Chile, my country, Latin America, every day we are learning and caught the real meaning of data protection and privacy and the full relevance of these topics. And we think it's necessary to share with the many colleagues around the world, because we are recently modified our constitutional text to recognize the data protection and privacy as a fundamental right in our constitutional text. Article 19 of Chilean Constitution says, the Constitution assures to everyone, number 4, a full respect and protection of privacy and honor to the person and its family. Also, the protection of personal data and the treatment data protection will be made conform a new law. This new law or new act is in this moment under full discussion inside our Chilean parliament in this moment. The Constitutional Committee of Deputies and Senators are approved since 2 weeks ago, the articles about this matter. Well, from this relevant fact, I want to share with you, several sentences, decisions of our Supreme Court and Superior Court of Appeals in different parts of my country are asking more arguments, solid basis of evidence, in example, from the fiscal prosecution to give register warrants, orders of interception of digital communications measures, and more. For that, because in this moment, the data protection and privacy is a civil right. This is one step ahead in the 4.0 rule of law, like Andrea is saying. It's a new framework for us.
Juan Carlos, this is very interesting, and I can understand that your explanation comes a lot from your personal experiences. And I believe that among colleagues, among lawyers, among experts, there is nothing better to understand the dynamics and the extension of rights and protection of rights than learning from personal experiences. So can you share with us some more of your personal experiences, some cases that are related to human rights and privacy or data protection in particular?
Yeah. When you are working, for example, in criminal proceedings or very complex matters, the data protection and privacy tools to work and define strategies for litigation or in the end of the path to defend the form more effective the rights of your clients. In this moment, the new order of data protection and privacy give us like a lawyers, like a defendant lawyers, a new tools, very strong tools to represent before the courts and the high courts with emphasis, with energy, and very, very strong and solid arguments in front of the superior courts to say, Your Honor, in this moment, you are confronting a new reality. In this new order, you have to analyze these new problems with new forms, with new points of view. You have to need to adapt the comprehension. The most people in the world in this moment are working in a digital world, in the e-commerce, for example. The more relevant aspects of the life, every day the people are coming inside the digital scenarios of spheres. Your Honor, Mr. Judges, you have to adapt new knowledge, and us, like defendant lawyers, every day we have to work, we have to study, we have a very strong labor, because our final goal is only one, to aid to the justice to make best decisions over the civil rights of the people, because the impact will be very, very relevant if we have not these measures of keep.
Juan Carlos, thank you very much. And what I would like to share with the African Bar Association colleagues as an audience is the fact that Juan Carlos has become one of the most prominent experts in Chile. He's too humble to say this, but he often releases interviews to Chilean TV channels and Chilean newspapers on these very same topics. And he is also a strong advisor of the Chilean Parliament, of the Senate in particular, and other important associations in Chile. PrivacyRules is supporting Juan Carlos, his law firm, as our exclusive member for Chile, in order to help the government and the legal environment in Chile to progress also in line with the so-called best international standards. So I strongly invite all the African Bar Association colleagues to contact Juan Carlos in order to get information, consultancy from him on how privacy and data protection as human rights can be promoted. We know that the African Charter for Human and People's Rights is not clearly defining privacy as a right of the individual, but through similitudes, through international experiences, also through the experience of the Inter-American Court for Human Rights, where Juan Carlos often goes to litigate, we can definitely help the African colleagues to develop, to foster, to enhance the environment of protection. Juan Carlos is a passionate speaker, so you could definitely have and receive his advice as the one of his firm. And definitely, we strongly recommend any of you, dear African colleagues who have business in Latin America, to consider Juan Carlos and his law firm for advice. I know that time is running, and that our dear colleague, exquisite President Hannibal Uvaifo, wants to move forward with the next presenter. So we thank you very much again, dear Juan Carlos, for having been with us and with all the African colleagues today. it was definitely an enriching experience. Thank you very much.
Thank you.
Thanks you, and bye.
Dear distinguished members of the African Bar Association, we are very pleased now to continue the series of our interventions related to privacy, data protection, and now cybersecurity, giving a warm welcome, I'm sure on behalf of you also, to Mr. Ken Morris. Ken Morris is speaking with us from the United States. He is the founder and also the CEO of ConnectIQ, a cyber technology company, which has created a very innovative software for the protection of data in flight. Definitely Ken will explain to us what we are talking about, but definitely he has also the advantage of being a lawyer, like all of you in the conference room. So he's a colleague of all of us. So he has this hybrid nature that definitely is perfect to explain to lawyers, to colleagues like you there in Monrovia, why cybersecurity is so important and what is the contribution that lawyers and technology experts can offer. Dear Ken, the floor is to you. We would welcome a short introduction for you, and then we will have some questions for you. Thank you.
Good afternoon, everyone. And thank you again, the team at PrivacyRules and Hannibal as well for this opportunity to be with you today. We're going to spend a few minutes talking about some of the challenges today with complying with this growing landscape of data protection regulations and regulatory frameworks that are cropping up around the country. And so we'll have a series of questions that we'll run through. I will give some examples of some of the challenges associated with today and how that is not meeting the particular requirements, not only under the GDPR, but most other frameworks, but also what you can do about it in terms of protecting data in flight, because that is the largest threat surface for any organization if they're trying to protect personal information and personal identifying information.
Okay, thank you, Ken, for being with us. I would like to immediately start asking you something very general that is related to the fact that data protection is actually a global phenomenon that is accelerating day by day. So I would like to know what are your thoughts on the drivers and influencers for this?
Sure, thank you. The GDPR is probably, even though there have been privacy frameworks for decades, GDPR is really the one that started this global understanding and focus on how do we begin to maintain security around these data, and not just at rest, which is historically what people have done, but also in flight. And right now, at least my last count as of 0900 this morning, there are 132 countries that now have a data privacy framework. Of that, there are about 28 that are really looking to do some novel things and model it more after the GDPR. That raises interesting challenges and questions for your clients. And it could be enterprises of all sides, government, military, the commercial sector. Current security frameworks are a bit subject and suspect in terms of trying to help solve some of these problems. But this, if we see the data breaches that are occurring globally, the lack of trust in organizations like Facebook and Google, British Airways just had a breach that was fairly significant. The sense around the globe is that tech companies, and it's not just tech companies, it's anybody that's using technology, which could be a law firm, it could be a commercial business of any type, the ability to protect these data is now coming into question. And the GDPR does speak to, as do a number of other privacy and security frameworks, it speaks right to the heart of, at the end of the day, this is about, are you treating these personal data fairly and honestly, and doing it in a way that still allows you to operate, but it also honors the privacy concerns that individuals actually are now expressing.
Ken, excellent. This is truly very interesting. Let me ask something that is specifically related to the GDPR that you mentioned. There are many organizations, in fact, that believe that they are meeting Article 32, either under the GDPR framework or under regulatory frameworks. and that by encryption they can secure to comply with those frameworks, maybe the data at rest or in flight. Now, based on your experience, and again, your precious experience as a cybersecurity expert and as a lawyer, do you believe that encryption meets the ongoing confidentiality and integrity of the supporting technical systems?
The short answer is no, although it is convention that encryption, which is required under the framework, that you should be encrypting all data, certainly at rest, but our focus is on flight, which is a greater threat surface. A lot of that is because most organizations, and these are individuals and lawyers I would count among that group, aren't really clear on what is the threat surface associated with encrypting data. It's not the encryption itself. The process of encryption is solid, it's mathematics, it's fine. The problem is there are a series of characters, we call them encryption keys, and the protection of those is what's vital. Most organizations don't really protect those very well. And so if we think about where adversaries are, what they've been able to do in terms of their skill sets, if we think only about encryption and fail to understand that the threat surface is the storage of those keys and protecting those keys, which it is literally a straight shot through. If I get a copy of your key, I can now decrypt your data in flight and you don't know it. There's no early warning system, and unless the bad actor makes a mistake, you don't know that these data have been compromised. And so as the data protection commissions are beginning to look at this question, they're realizing that in fact, while we say you should use encryption, and there's no real specificity about how you do that, understanding where the threat surface is vital if in fact we're going to provide good counsel to our clients and our customers.
Welcome, thank you. And following this point, in particular in relation to the security of processing that is related to this article of GDPR, I would like, and considering that today hackers have all the skills and requisites to, challenge the current best practices, I would like to ask you, how might those seeking to assure, ongoing regulatory compliance to meet Article 32 and its requirements?
Well, it's interesting because if we parse Article 32 closely, it requires not only that you're using encryption in these tools, but it also has to be effective. It also has to assure integrity long-term in the process. One should be assessing, is the tool set that I'm currently using helpful long-term? Well, if you look at how encryption works today, and we get back to the encryption keys, hackers have, and nation states are doing this today, they understand that if they can capture the key that's in a vault, and it becomes an infinity problem. So today, current practice is, I will have an encryption key, a private key, I will lock it in a vault. Then I will secure the vault with something else, some other form of a key. So now key number 2 is unsecured. So best practice, I take key number 2 and put it in vault 2. Now I have key 3 that secures vault 2. You can begin to see the problem here. There's always a key left exposed at the end. Adversaries and hackers understand this. So very rarely do you see brute force attacks on data anymore. It's just too easy to go and actually get a copy of the key. And what's particularly pernicious about this process is if I have your key, first of all, if I have a copy, you don't know that. Secondarily, if I'm decrypting your data, you still don't know that that's occurring as well. So focusing strictly on encryption and not understanding the underlying threat surface is problematic. And in fact, I would argue it contravenes the very purposes of the GDPR, which is to assure confidentiality and integrity.
Ken, anything that you're explaining is really interesting and precious. You have spoken about the GDPR that progressively the entire world is getting familiar with, the concept of best practices that us as lawyers know what they are. Please let me ask you, if you can speak to us about privacy by design, and if you also can explain to our colleagues what privacy by design is, and if in your opinion, encryption of data in flight complies with the current principle and concept of privacy by design, and if it doesn't do so, what do you advise? What do you advise to our lawyers who have to advise their clients how to protect data?
Well, privacy by design is a process where, when you're building any process, any framework, any technology, you're considering privacy and data protection from the grounding of, in this case, the actual code that you're writing. We need to go back to understand how we started connecting data on the internet to get a perspective here. Originally, computer scientists were excited about connecting computers. They talked to one another. We didn't think about security, we didn't think about privacy, it was about they were connected and they were speaking. Later, we thought about, we probably should begin to secure these data. Well, cryptography has been around for thousands of years, works fine. And so we began to overlay the concept of cryptographic modules, and there's all types, to secure the data. And to do that, you have to have a cryptographic key. So that's that key I talked about earlier. And of course, we have to protect the key. If we look at that entire process and structure, privacy by design, data protection by design was not part of how this whole episode of sharing data between computers and devices began. So fundamentally, we created single points of failure, and whether that was intentional or not is another argument, but we created them in the sense that we didn't design security into the process. So it raises questions. What do you do today? Because best practices in terms of the technology in use are fundamentally flawed in that regard, in that they're built on the foundation of you connect first and then you deal with the security later. And the solution we see is to you take privacy by design first in terms of identifying who's on the other end, and then you connect. That is orthogonal to current practices that we see in any other technology. And what we've done at Connect IQ is to build trust environments that actually allow for, you get the parties know one another, the technology is known to each side. Once that is established, then data flows. That is a bit orthogonal and different, and we understand that, but now that is, since it's built from the ground up to secure data in flight, you don't literally have the worries that you have today with something that is fundamentally unsound. And we would argue in the 21st century cannot meet the requirements of the GDPR to assure that you are protecting these data.
Excellent. Ken, I'm sorry, but I definitely want to take 1 minute of your time more for one last question. You have been traveling all around the world. You constantly travel all around the world. Anytime that I speak with you or I write to you an email, I find you anywhere in the world, and it's very interesting. You're really a globetrotter. What kind of advice can you offer to our African colleagues who want to advise or can happen to advise their clients on data protection and cybersecurity? If you can list for them 3 key priorities that in their legal counseling and legal advice they should take into consideration for their clients.
Well, number one is to think about the concept of what we call redemptive compliance. We do believe that data protection authorities around the world will, in fact, be leveling fines. That's probably going to occur. So the question becomes, as you're providing advice and counsel to your clients, help them understand and begin to ask and answer these questions. First of all, are you encrypting? If the answer is yes, and in most cases that's true, ask who has protection control of your encryption keys. Most places are using a key management as a service somewhere. If that third party actually has protection and control and access to your keys, eventually what happens is they have the ability to decrypt those data And it doesn't matter how many agreements the lawyers sign, the company, and it could be an Amazon, it could be Azure, it could be DigiCert, it doesn't matter. They have the capacity and capability to decrypt those data. They are a third party unrelated to either a data controller or a data processor, because all they're doing is supplying a key, but they have a copy of the key. And so you're starting to run afoul of the rules, basically, around efficiency, efficacy, does it work, is it secured, is it confidential? So that's one thing. Secondarily, if your company is using current systems and best practices, which we're finding are turning out not to be so best, we would advise them to find tech providers who eliminate the need to store keys or secrets for all data in flight. Because if you remove the threat surface, you don't have to worry about it. So the key generation happens where it's supposed to happen with the sender, and then the keys disappear, and then the keys are regenerated with the receiver, and the receiver is able to decrypt the message. And you eliminate the storage, again, of these keys or these secrets. Finally, as the GDPR does not specify specifically what you have to do, it's the burden and the blessing, I would argue, of being open when it comes to standards, because it allows for growth and mutation and changes and development and technology that needs to occur. But at the same time, it gives companies freedom to try and solve it. The challenge here, I think, that lawyers will have with their organizations is helping, and it could be with the lawyers themselves, is helping them understand that the fact that there's no prescriptive process does not excuse one. You still have to meet the underlying objectives, which is when these data are moving and in flight, can you state that they are free from the ability for someone to decrypt and read these data? The challenge with today's technology that is currently considered best practice is that will not get you there. And so what we've done at ConnectIQ, there are other companies that are looking to do this as well, is to remove the threat surfaces that are associated with creating the lack of assurance that these data will remain secure as they move from place to place.
Excellent, Ken. This is truly, really interesting. So thank you very much for your contribution. And once more, we are very pleased to have you as one of the technology companies member of PrivacyRules. We will recommend definitely to all the colleagues who are listening to us there in Monrovia to advise their clients to come to us and to come to you and to see the services of ConnectIQ. Thanks for your explanations. I'm sure that they were interesting, convincing for all the colleagues there in Monrovia. Together, we thank very much President Annie Maluba-Ifo for hosting and organizing and supporting the presence of all of us in order to address the distinguished colleagues of the African Bar Association. We will meet again, definitely, with Ken very soon in Toronto, with the colleagues from Africa, hoping to have them on board of PrivacyRules Alliance in the next months. Thank you very much and have a good day.
Wonderful, thank you.
Thank you very much. And this is the end of this interactive session that we just had with the African Bar Association and the member of PrivacyRules. And I would also like to invite all the people of the audience to send us as more questions as they can, because we would be pleased to reply them also with our videos or with all the means that we have to give them all the answers that they need. And they can contact us to the email info@privacyrules.com. And I will leave the word to Andrea for his conclusions. Thank you very much.
Thank you, Alessandro. My very brief conclusion is to underline three distinctive elements of PrivacyRules, thanks to what actually our colleagues have said. The first one, Janet, as you could hear, Janet Othero from OK Law in Kenya, has spoken to us about how important is the cooperation of law firms with the government, with the institutions, in order to enhance the legal framework related to privacy, data protection, technology law in the respective jurisdictions. This is one of the things that PrivacyRules does. Works with its members in order to create an environment of legal rules that are in support of privacy and data protection. And thanks to joining PrivacyRules, we will be ready to help you doing the same in your countries in Africa. We will be very pleased to do that. The second element, our distinguished colleague, Juan Manriquez from Chile, is one of the main litigators in front of the Inter-American Court of Human Rights, and has spoken to us about privacy as a human right and a fundamental right. By joining PrivacyRules, by coming and working with us, you will understand actually that privacy is definitely an opportunity. Data protection is an opportunity in order also to litigate and promote privacy as a human right in front of all the authorities that you have in your honorable countries. And the third presenter, Mr. Ken Morris from the technology world, from the cybersecurity world, but as a lawyer, as we explained to you, has given a fundamental contribution, because in PrivacyRules, we are bringing together around the same table lawyers and technology firms in order to generate business altogether, to be in the condition to serve your clients from the legal perspective and the technology perspectives. So we were very pleased to speak with all of you, distinguished lawyers of the African Bar Association. Thank you so much for listening to us, because you could see the different souls of PrivacyRules. And we hope that you will decide to join our alliance. And once more, we could not thank more the Honorable President Hannibal Ubaifo for being such a passionate and convinced supporter of the promotion of a culture of privacy in Africa and through Africa, from Africa, internationally. Hannibal, I would really like to thank you on behalf of the entire PrivacyRules Alliance. We are present, as you know, in 40 jurisdictions already, and we are growing internationally, and you are an incredible partner to all of us.
Thank you so much, Andrea. I want to thank you for the love and passion you have for the PrivacyRules and for the way you have been able to put the World Alliance together. The meeting in London was very impressive. I didn't know that of Toronto is also going to be very impressive. And we are going to have a lot of things to bring back to members of the African Bar Association and to the next year's conference, wherever it will be. I want to thank you, Alexandro. I want to thank all the panelists. I want to thank all our participants and members of the African Bar Association, the audience for finding time to look at it. Questions, a lot of questions to ask. The panelists will be willing to take your questions once you send them through the African Bar Association. Once again, thank you for listening to the PrivacyRules, and we wish everybody a very happy time in Monrovia. Thank you.
Thank you. Thank you very much, President.
Thank you very much.